Okay, so time for another checklist. This time, checklist of topics you need to be comfortable with under Dormant Commerce and the Privileges and Immunities Clause of Article 4. We start, of course, with the notion of discrimination, right? You need to know when a state law discriminates. It discriminates when it erects barriers to trade or when it treats in-state and out-of-state interests differently. You don't fight the fact pattern, right? If you see any different treatment, okay, you get one price, right, if you're a citizen of this state, and another price if you're a citizen of another state, right? You get one tax if you're a citizen of this state, and another tax if you're a citizen of another state. Any difference in rules between out-of-staters and in-staters, right? You're going to find that the law discriminates against out-of-staters. So we need to keep in mind that we're looking for discrimination against out-of-staters with regard to private business interests, right? Or I should say, in favor of private business interests within the state. If the government is not favoring private interests, right, from within the state, we don't have protectionism going on, and that's why you have the 2 bullet points here under discrimination, right? If the state is actually in a market, right, is in business, then you may be looking at the market participant exception, right, to the rule against discrimination, which of course leads to strict scrutiny. That's coming up next. But if you see the state actually in business, okay, and that's, again, not a hard thing to spot. And you would not talk about the market participant doctrine unless you spot it, right? When you see the state actually getting into some business, right, then the state is allowed to discriminate with regard to the business that it's in. Remember the Alaska timber case, you can't discriminate upstream or downstream from the business you're in, but you can discriminate with regard to the business you're in favor of in-state interests. Furthermore, under United Haulers, right, the government, so this talking either state government or a city government, I can't conceive, maybe county government, but it applies to subdivisions, but usually you're going to see a state or city, right, either one, discriminating not in favor of private interests within the city or within the state, but in favor of itself, right? And when I say a state is discriminating in favor of itself or a city is discriminating in favor of itself, I mean in favor of the government, right? The state government, some state government agency, or some city, right, government, municipal corporation, right, an entity that is actually controlled by the government. So discriminating in favor of the state or discriminating in favor of the city under United Haulers does not mean discriminating in favor of the people of the state or the people of the city or the private interest in the state or the private interest in the city. It means discriminating in favor of the state, right, a state-owned agency or authority itself or a city-owned agency or authority itself. So that's when United Haulers applies. Otherwise, discrimination is a problem, which triggers the next thing you need to be comfortable with: strict scrutiny. Okay, if the government, the state government, is treating in-staters and out-of-staters differently and discriminating, then we get strict scrutiny. I trust that by now you know how that means, or how that works. The means have to be narrowly tailored, right, to the achievement of a compelling interest. You have to lay out what narrowly tailored means, what a compelling interest is, right, and you go to town. And of course, the likelihood is that under strict scrutiny, the government is going to lose. Now, if a law does not discriminate, and there are plenty of laws that don't, right, if it treats everybody the same way, it's quote-unquote even-handed, then you apply the Pike test. Now, keep in mind, right, that even a law that looks innocent and even-handed on its face, right, like it does not discriminate on its face, if you see facts in the fact pattern that the state legislature or the city council or whatever it was wanted to target out-of-staters, you still might wind up with strict scrutiny, right? Because of the purpose or effect, right? And really, you want to look at that as if it, on its face, right, the law discriminates, or ordinance, whatever it is, or if it was meant to. I think that would be actually a better way for courts to put it, but we're stuck with the language they use. Either way, you're going to wind up with strict scrutiny. So if there's no evidence of messing around here, right? If on its face it looks even-handed, then there's nothing in the fact pattern about the state trying to target out-of-staters or the city trying to target out-of-cityers, then you would apply Pike. And you know that that is a deferential balancing test, right, that favors the state, under which a law would only be struck if the burden on interstate commerce clearly exceeds, right, any local benefit. Next, Privileges and Immunities Clause of Article 4. You need to be comfortable with that, right? You need to realize that it only applies to certain fundamental interests, right? Like working in another state, traveling to another state. There's a lot of that going on now, right? Interstate travel, acquiring property in another state, establishing domicile in another state, right? Those types of things will also raise a P&I issue. Now, you need to be comfortable with that, but I've expressed to some of you individually, right, P&I is not that big of a deal, because if you, in practice, right, because, you know, if a state is discriminating against out-of-staters coming into the state, you're going to get strict scrutiny under dormant commerce principles anyway. But privileges and immunities, look at that as sort of a backup claim, right, to a dormant commerce claim, where you're saying not only is it a dormant commerce violation, but also it is a privileges and immunities violation because it affects one of those things, right? Working, traveling, acquiring domicile or acquiring property, establishing domicile or acquiring property. Finally, know the difference between dormant commerce and preemption, right? And that preemption is a supremacy clause issue. Under the supremacy clause, right, if you have an actual conflict between a state law and a federal statute, right, the federal statute or the federal law, whatever it is going to trump, right, the state law. Under the supremacy clause, the U.S. Constitution, right, statutes passed by Congress and treaties, assuming that they're valid, right, statutes and treaties, right, are the supreme law of the land. Anything in right, any state law to the contrary notwithstanding. So these are the topics you need to be comfortable with. I want to mention before I'm done with the video, you also obviously have to be familiar with the text that applies in these cases. When you're talking about state power to regulate, I would always cite the police power. I would always cite the 10th Amendment. If you're talking about dormant commerce, you would also cite the the Commerce Clause, right, which gives Congress plenary authority to regulate interstate commerce and therefore suggests limits on state power. And of course, if you're talking about the Privileges and Immunities Clause, then you're citing Article 4. So that is a wrap on the big issues, right, with regard to state power to act. If you have a good handle on these things, you should be good to go. If you're rusty on any of this, it's back to the books before the final. So with that said, as usual, be well, stay safe, and stay tuned.